Good afternoon, everyone. The first appeal on this afternoon's calendar is appeal number 11, CIT Bank versus Schiffman. Counsel?
Good afternoon, Your Honor. My name is Samuel Katz.
Good afternoon, Mr. Katz. May begin. Oh, wait, let me wait for your counsel, excuse me.
Mr. Katz has no video.
Do we have audio from Mr. Katz?
Good afternoon, Your Honor. I'm sorry about the technical difficulties getting on.
No problem, sir.
May it please the court, my name is Samuel Katz. I represent the defendants, appellants Pamela and Jerry Schiffman. May I reserve 3 minutes for rebuttal, please?
You may, sir.
Thank you, Your Honor. In this appeal, I respectfully request that the court hold that a lender's proof of compliance with RPAPL 1304 using a standard office mailing procedure be deemed deficient and rebutted when the borrower denies receipt of the notice and there is proof that the lender's standard office mailing procedure was not followed in a material manner. In this case, the borrowers both denied receipt of the 1304 notices and also proved that the lender's own stated standard office mailing procedure was not followed. The particular defect in this case revolves around the time that the notices are created for purposes of mailing them to the borrowers. The lender's affidavit stated that they create these notices upon default.
Question, if I may. Mr. Katz, I just want to be clear. Are you taking the position, have you conceded that the plaintiff is entitled to a presumption of receipt? And therefore, the only question that's really been certified to us, as I understand the certified question, is whether the defendants have sufficiently rebutted that presumption. Is that your understanding of the posture?
Our position is that the stated office mailing procedure presents a presumption of mailing, which then transfers the burden onto the defendant to deny the presumption of receipt.
Well,
but I believe,
can I ask the question a little bit differently from Judge Feynman? Are we bound by the federal court's determination that there was sufficient adequate proof of mailing in the first instance? I know you refer to the problem of the timing. And I think at least arguably there is questionable proof about the practice, the standard office practice of how these notices are actually mailed, how they get to the post office, for example, would be one part of that. So is that something that we can consider here, or are we limited to looking at this time gap that you refer to?
I don't think the court is limited at all. I believe that the court has the ability to look at the lender's prima facie burden, and this goes to the lender's prima facie burden on summary judgment to present a proper mailing office procedure. On its face, it has to be a proper and reliable mailing office procedure, which our position is that the bank in this case did not present, and therefore the court does have the ability to look beyond what the federal court had said to see whether or not the lender even satisfied their prima facie burden.
So that would be different than what you said at page 22 and 23 of your brief, where you said CIT created only a rebuttable presumption of receipt by the Schiffmans, which I took as a concession that they had done that.
I don't think so, because I think the concept is kind of a fluid concept, because it begins with the proof of mailing, which the borrower cannot, the borrower under normal circumstances has no ability to impeach the lender's standard mail offers procedure. So the only way that the borrower can then deny or object or raise an issue of fact as to that is by saying, A, I didn't receive the notices, and B, the notices were not even sent in the way that you say that they were supposed to be sent, because you didn't follow your own stated office mailing procedure, which in this case, actually, the lender admits that they didn't follow. It's not a question of fact whether or not the lender followed their stated office procedure.
If I can ask, what is their concession specifically? What are you saying is the part of the procedure that they did not follow?
The lender's affidavit stated that upon default, the lender creates the notices and then mails them out in accordance with their standard office mailing procedure. The affidavit attempted to describe what the office mailing procedure is, and then it went ahead and said that in this case, based on the business records that they have, she attests that the procedure was followed.
Yeah.
However, the procedure is contradicted by their own statement. In their own affidavit, the procedure is contradicted by the fact that it was not created upon default, and it was in fact created.
If I can just interrupt you, but could not one understand the representations as meaning upon default when they have notice of that default? I thought there was a question as to whether or not at the moment of the default,
So
they would have been able to proceed because they're not the holders.
I'm not sure I follow your question, Judge Rivera.
Okay, so let me ask it a different way. Who had control over, or who had the responsibility of filing notices at the moment of default?
The lender.
Yes, I'm asking, who was the lender at that moment?
Well, I believe it was a CIT Bank's predecessor, perhaps.
Okay, so that's what I'm saying. Can we not interpret the representations as meaning upon default as long as they have notice of that default? So if they now are holding the note after the default, it's when they know of the default. Isn't that the way one could interpret the representation?
I'm not sure I'm following completely, but if I understand correctly, the lender, the current lender, CIT Bank, stands in the shoes of the predecessor. But it acquires ownership of the note, it acquires all records related
No,
to
I understand, but you're basically are, if this representation is as I suggest, then there is no defect. It's not the defect that you refer to. Let me just put it that way, right? Once they have the note, they look at their records, they see there's a default. The default may have been months ago, and now they act on it.
Okay, yes. So
That's their process. Is anything that they have said in their representation? I'll ask your adversary the same question. Is there anything they have represented at odds with that understanding of the process?
well, the implication from the words upon default is that the event triggers the creation of the notices, the event of default. And you would expect that that the creation of notices actually occurs within a reasonable time frame, either simultaneously with the event of the default or within a reasonable time frame. 9 months, 10 months is beyond the reasonable time frame, and therefore it impeaches their own stated procedure.
I know, but I'm just saying your presumption is that they had the authority to issue those notices at the moment of default.
At any time that there is a default, there is a lender, whoever owns the note has the authority. So if it was CIT Bank, then it was CIT Bank. If it was their predecessor, then it was their predecessor. But it should have been complied with within a reasonable time within the event of the default. Because if you have a stated procedure that requires a triggering event to create the notices, they have to happen within a reasonable time frame of each other. Otherwise, the procedure is not a reliable procedure. And that's what we're looking for over here.
Judge, may I ask a question?
Yes, Judge Beatty.
Thank you. In another context, say in insurance cancellation, which is a similar kind of problem to the problem we have to deal with here today, what would be required would be first for the person who is canceling the insurance to follow standard office mailing procedures in both the preparation and in the mailing of the particular notice that will be sent out. And then there's a presumption of receipt by mail that's then created. The way I understand your argument is that you didn't receive it, and that the presumption of receipt by mail was not properly created. Is that correct?
I'll try to explain it again, but I believe that
stick with my question.
Sure.
Is what I just stated correct? Is that what you're seeking to prove here?
It's partially correct.
All right, then correct me or add on whatever you feel needs to be added on.
Okay, so basically the way I understand it is that the presumption of the mailing itself cannot be rebutted by the borrower or by the person who's supposed to be receiving the notice, because they don't have knowledge of whatever the lender.
Let me stop you there. You have the Hook affidavit, is that correct?
Correct.
Right, and the Hook affidavit would necessarily have to set out both the preparation of the notice and the procedures by which the notice was mailed out. Isn't that what would be required?
That's correct.
All right. All right. So you do have proof about how it was put together. And the question is for us is, was that sufficient? Was that Hook affidavit sufficient? If
Correct.
It was sufficient, then the burden shifts to you, right?
Correct. Well,
All
yes.
right.
So
All
what
right.
I'm saying is that the Hook affidavit was not sufficient because the
All right,
procedure
so let
that
me
was
stop
presented.
you. Let me stop you. If you're saying the Hook affidavit was insufficient, then you're saying that the initial presumption of mailing was not properly created and that the CIT, the plaintiff, didn't meet their initial burden. Is that right?
That's correct, Your Honor.
Okay, go ahead.
Here's, if I may, what I don't understand. I thought that the Second Circuit already resolved that question factually and said there is a presumption of receipt, and what they're asking us is not what do you have to do to establish a presumption of receipt, but what do you have to do to rebut that presumption?
Right. That's the Second Circuit's question does appear.
You're not asking us to reframe the question. You haven't done that, have you?
We have not done that, but of course, the Court of Appeals is more than has more than the requisite authority.
Why would we do that if the Second Circuit has already made its factual finding that the affidavits and whatever they had in front of them sufficiently establishes the presumption? I mean, we're not because we're not resolving this appeal. All right, so this is not a matter of us correcting a factual mistake by the Second Circuit on that, assuming they made a mistake. I'm not sure I think they did. We're just being asked to answer a question of law, and they'll decide the appeal.
That's correct, but I think it goes hand in hand because because the presumption of mailing, as I tried to explain before, the presumption of mailing itself shifts the burden to the borrower to rebut. But the way to do that is by rebutting the receipt of the mailing and then by presenting some kind of a defect in the procedure. So
yeah, going round and round on this. I didn't know if there's anything you wanted to say about 1306 and the second question that they certified to us.
Yes, Your Honor. Our arguments on 1306 is very simple. 1306 and 1304 go hand in hand. The requirements of 1306 are that all the notices that are sent to borrowers pursuant to 1304 are then recorded in a statement to the Department of Financial.
Don't those two statutes serve, at least in part, some very different purposes? I mean, the ultimate goal clearly is the same, but it appears that, pretty clearly that 1306 is for the purpose of getting general information on the types of loans that are going into foreclosure and where they are and where to put resources into helping homeowners prevent that. And why is it necessary for every borrower who's presumably often in the same household, why would it be necessary to have every single borrower listed on that filing?
Well, there's evidence in the record that the Department of Financial Services, aside from being a statistical function, they also have the ability to reach out to borrowers who are in default, who are at risk of losing their home, and to help them get back on their feet if they can. There is a double function over there. It's not only the statistical data that they collect, and that goes hand in hand with 1304, which is to provide notices to the borrowers, to each of the borrowers.
Do we owe any difference at all to DFS, which is implementing this whole scheme of 1306 and what they think?
I'm sorry, I missed the first part of your question.
Do we owe any deference to what DFS thinks?
I do not think so. DFS only provides guidance, and it's not binding on the court or on anyone. But the court can look to the legislative intent of 1306, and I think here you have both the statistical data and the purpose of trying to assist borrowers, trying to reach out to borrowers, and trying to see if they can avoid a borrower losing their home.
Thank you, Mr. Katz. Counsel?
Thank you, Your Honor, and may it please the court. Sean Murata for the respondent, CIT Bank. On the 1304 issue, let me be clear. The argument that Mr. Katz has been making is quite different than the one that this case has been certified to this court for, or even that he says in his own brief. As noted at page 22 and 23 of his own brief, and in the certification order. Can
I just interrupt you on that point? Because, I think it's a significant issue for our consideration. But if, as I look at the bank's standard operating procedure or office procedure as set forth in the affidavits and everything else, there's nothing in there that says how these it talks a lot about how the notices were created and where the information came from and what went on the envelopes and what went in the envelopes and all that. But I don't see anything other than a very conclusory statement that, and then they're mailed or then they're sent for mailing. How could a borrower rebut the standard office procedure regarding mailing when there is no procedure that's set forth by the bank? How would that be possible?
I guess a borrower in those circumstances, if you were to think it's conclusory, could say that what you have set out is not a standard office procedure, such the presumption never arises. But the Schiffmans have never argued that in this case. To the contrary, they have always conceded that that affidavit is sufficient to create the presumption and constitutes a standard office mailing procedure. And I think that that concession is important because if they had made that objection in the district court, perhaps we would have come back and said, okay, well, if your problem is you haven't explained to how the mail gets from, the guy in the mailroom to the postman, we'll give you more information. But now at the Second Circuit and now in this court for the first time, there is the suggestion raised that that line isn't doing enough. And I think that's far too late to spring that kind of objection.
Here's the problem. Judge, is there if I ask you? Okay. The problem with that is that we don't really decide the factual issues here. And one of the things we would have to be concerned about is not so much the facts in this case and how the Second Circuit will resolve it, because that's really up to them. It really isn't up to us. You're right about that. But But Judge Stein's point, and I agree with it, is that we have to lay out for them the way we understand the law, and then they have to apply it. And so if we look at it, and not to say that respectfully, of course, that the Second Circuit misperceived the law, but that our understanding of the law requires them to look at that initial presumption and then see if the burden was met in response to that. Lay it out for them, and then they look at the facts, because they're in appellate court with subject to factual review, which we really aren't, and they can decide if their understanding of the facts fit within our understanding of what the law is. And I think that would be the only reason for us to address it. The factual determinations, one way or the other, of course, it'd be up to them. But if we didn't address it, I think as a public policy matter, we would be perhaps creating a situation in other areas, like I referred to, like insurance law, where we could create problems for ourselves if we didn't clearly set out what the rules are. That's why I think it's important.
So Judge Fahey, I think you can do two things in response to that concern, which I agree is a real concern. As we lay out in our brief, this case kind of comes to this court. The Second Circuit certification order maybe made the record seem a little bit clearer than it was. So first, you could perhaps say that maybe the first question that was certified isn't actually dispositive of the case, because there is this concern about whether the presumption arose in the first instance, and maybe the question wasn't properly certified in that case. Or second, what you can do is you say, look, we take the case as it comes. We will assume without deciding that the presumption was created, and here's what you have to do to rebut it. Whether there are concerns or not about whether, in a different procedural posture, you would think the presumption is created or not. I think you could go either way. But I don't think what you can do at this late date is say, oh, wait, no, what we're actually contending is that there was no presumption in the first place. But I think it's telling that the Schiffmans move in that direction, because when you actually get to what comes to rebutting the presumption once created, you have to show that something went wrong with the mailing. And I think this gets to your question a little bit, Judge Rivera. The Hook affidavit said, we create the notices upon default. As the Second Circuit noted, default here means because CIT Bank was not the owner of this loan when it went into default, it was best understood to say, once we got the loan and realized it was in default, we created the notice and then sent it out. And of course, it's notable that no one thinks that this notice was...
If I can just interrupt you there, I think this is the point. Yes, your argument that it means upon default, if you're the holder of the note, and otherwise upon acquisition of a loan that's in default, once you realize it's in default. That is your procedure. Now, why the affidavits don't make that distinction, I can't say, but I understood that was what you're arguing is the procedure to address what your adversary calls the defect in the procedure, right? He's working from the assumption you waited 11 months after the default to mail this, which may suggest that the rest of your process is one that's not followed. Right? It puts in question the reliability of the rest of your assertions regarding the process.
I think that's right. And even if you think it's a defect, it's not a defect as to mailing. I mean, no one questions that this notice was generated. We have the notice in the record, and the Second Circuit has rejected the arguments that, the notice attached to it wasn't properly verified or something like that. So really, it's a question of, has it been mailed? And what my adversary says is, well, there's no way you could actually rebut the presumption. But of course you can. And cases are legion where people have. For instance, the envelope is in the record, the scan. They could look at that and say, well, the way that letter is addressed, there's no way it's getting to us because it's on the wrong street, or you've addressed it in such a way that the post office wouldn't deliver it to us.
Well, if I can interrupt there, well, that goes to the reliability of the process to actually achieve the purpose, right? That they get the mailing, that they receive it, right? You don't want to create a process which is so flawed that no one's ever going to receive the notice, right? So that goes to that. But I think Judge Stein and others are asking about what in the process confirms the way one mails. And that is what the Second Circuit is asking about. Is any defect, right? So the question is any defect enough to rebut the presumption, or does it have to go to the mailing itself certainly the Court of Appeals could clarify, you must explain not only how you created the notices, how you generated the envelopes, how you ensured you got the right address and the name of the borrower, that you ensured the envelopes were stuffed. And then this is what you did to make sure, and you put a prepaid stamp. I noticed you have that on the envelope, you got the barcode. And then they walked it over to the post office. Or then they put it in the outgoing mail pile, which is collected every day at X, whatever that is. I'm not going to make up your process, but right, we could certainly clarify that. Whether or not you meet that is another story.
I would actually disagree, Judge Rivera, because I think all of that goes to what constitutes a reliable office practice. What I understand the Second Circuit to be asking is, if you have an affidavit that constitutes a reliable office practice, what do you have to show? How much deviation? In other words, if your normal office practice is that, Mr. Murata walks it over to the outgoing mail pile, but on the particular day in question, Mr. Katz walked it over to the outgoing mail pile, that's a deviation from the process because it's not our normal process. But you would say it's an immaterial deviation because it doesn't matter who does the walk.
Sure, but the process is someone walked it over.
Right.
Chief,
And of course,
if I might, Chief.
Yes.
So isn't the problem here, though, that unless you know with some specificity what the process is, you can't measure the deviation from the process?
I agree with that, Judge Wilson, but I think as this case comes to the court, there has been an assumption that has been conceded that a sufficiently reliable process has been set forth.
Yes, but we don't know what that process is. You're saying we could say you're saying what we're being asked is how much of a deviation constitutes a significant enough one to rebut the presumption. And what I'm asking is, if we don't know what the process is, how can we answer the second question, even if the process has been determined by the Second Circuit to be one that's viable?
Your Honor, I don't want to fight too hard on the suggestion that maybe this question isn't quite the one that you should be answering. As respondent, we didn't ask necessarily to be here. So, if the court were to say that the question were improperly certified, I think that's a result that is, understandable on the unusual facts of this case and how it came to the court. If I could address 1306 real quickly, unless the court has questions on 1304. On 1306, the simple fact of the matter is that in 1306, the question is, does borrower, which is what the statute use, mean borrowers? And there's a general rule of construction that singular means plural, unless the context and circumstances suggest otherwise. For all the reasons set out in our brief and on the DFS itself has laid out, the context suggests otherwise, given that the purpose of this is primarily to track loans, and to the extent it's to help borrowers, DFS itself has said, we can't draw distinctions between multiple borrowers who live at a single address. For that reason, we view it as...
If I can just ask this question, I thought that DFS does, on the form here, does allow for two borrowers. Am I incorrect?
It does allow for two borrowers.
Okay, so why didn't you just fill out the two borrowers?
I can't speak to why on this case two borrowers weren't on the form. But what I would say is for the statutory construction that's before Your Honor, which is does borrower mean borrowers? There is no basis to say more than one, but less than all. So if there's three borrowers.
But here's my concern. If DFS has itself thought that there is some value to both borrowers being listed, why are we not deferring to that? Are you saying it's just a pure statutory interpretation? They're wrong. They should only be asking for one. And if they ask for two, that's above and beyond. Oops, that's above and beyond. Sorry.
No,
What's necessary?
What I would say, Your Honor, is that DFS allows two borrowers to be listed because I think many homes are owned by married couples, Your Honor. But if you look at what they're...
Is there not some value in them being able to track that?
Well, what DFS says is that for when it's the principal dwelling of multiple borrowers, they have the same interest. And even if their interests differ, we really can't direct more resources to them. That applies whether it's one borrower or four borrowers. I think they allow two as a matter of custom, but there is nothing in the purposes that DFS has told you that would suggest
but doesn't the
two is the limit.
Doesn't the two borrowers, if there are multiple borrowers, maybe there are more than two, but if you've got two, doesn't listing both ensure that if one is an absentee, right, is an absentee borrower, that DFS, at least if they wish, can reach out to the other person?
Well, but I think that's contrary to what DFS has said, which is
Well,
and they
they are
acknowledge that.
asking for both.
I don't think they're asking for both, Your Honor. I think they have two blanks for both, which I think is different. But there is no suggestion on that website that, for instance, a form that only lists one is insufficient or
So then help
inadequate.
me here. Since I think now you're arguing it's to the lender's discretion. So how would that discretion be exercised to choose whether or not to list both?
Well, I think a form
This is the
suffices on.
DFS. How does that discretion get
Well, I
exercised?
don't think it's a matter of discretion, Judge Rivera. I think it's that one is sufficient. If you put both on, that's fine, but it's not required by the statute. What we are asking is it is required by the statute? And the answer is no.
Thank you, counsel. Mr.
Thank you.
Katz, is it rebuttal?
I'm sorry, I'm going to be brief about this. On the 1304, I just want to go back to the reliability aspect of the procedure, and the fact that the statute is a strict compliance statute. I want to emphasize that the method by which the lender, in this case, elected to prove compliance with 1304 is a less probative method, because it leaves the borrower without any real ability to contest the actual mailing, because there isn't a person that's swearing in an affidavit that says on this and this day I mailed out this and this affidavit, this notice to the borrower or to the borrowers. So because it's a less probative method of.
Mr. Katz, if I can just ask you, if they had an affidavit that said on this day I mailed it in the following way, and then explain the way they did that, would that be sufficient?
That would be sufficient, and the only way the borrower.
If all it said is I mailed it on this day, would that be sufficient? Without explaining what they did, would that be sufficient?
Well, it would have to be a detailed affidavit that says that they actually deposited and put the notice into an envelope, and it was mailed to the person that's listed on the affidavit, and they would have to have some details there, and that would only be able to be rebutted by a borrower with also a more detailed affidavit denying receipt. So, such as I have a system in my house where every time we receive mail, we put it down on a piece of paper and we record it. But here in this case, because they're using the less probative value and the statute is a strict compliance statute, I present to the court that the court should use a heightened standard when evaluating the burden of the lender in improving compliance with 1304 using this method.
Thank you, counsel.
Thank you, Your Honor.
You're welcome.